Hello. And my phone is ringing. Sorry.
Need to turn that down.
I know. Well, it also rings twice. So that's great. Well, hello. Welcome to Nevada Legal Services Now. We are here today for our Thursday live presentation. I am Rhea Gertken, and also with me, of course, is David Olshan. Hello, David.
Hello.
And today, clearly, we're talking about one of our favorite topics, PUA and overpayments. So, yay.
Here we go.
All right, so we'll go ahead and get started.
We are going to knock your socks off.
Probably not. Actually, this presentation does kind of go over a little bit that we've already discussed in previous presentations. David has a PUA overpayments video on our YouTube channel. We discussed the PUA documentation requirements, but people still are having difficulties navigating the system, and we'll try to do our best that we can to provide some guidance through this, particularly with the overpayment issue. So we will go ahead and get started. So first, about PUA documentation. I know in one of our last live streams, we did talk about this, but really more in the context of all of the changes that the Department of Labor had been making and the updates to the UIPL 16-20, right? 16-20. This is really going to focus on that change to the documentation requirements, because I know people are still facing disqualifications for PUA for this reason when they applied in March of 2020, July, or whenever the portal was actually open. So we just want to make clear that although when you initially applied, documentation was not required, it is required now. And that is true for all weeks of benefits. So yes, while you weren't required to provide documentation when you initially applied, you are required to provide it now. And you may have gotten a notice because this went into effect December 27th, 2020. You may have gotten a notice at the beginning of this year indicating that you now have to substantiate your self-employment in order to continue receiving benefits. So keep in mind, this is a requirement. This is really happening, and you do need to provide documentation to PUA. And we're going to talk about the two main areas where that is required. That's to support your weekly benefit amount, which I think, a lot of you know this already, that you were asked to provide your tax return for 2019 when you initially applied in order to support a higher weekly benefit amount. Otherwise, you would have just been eligible for the minimum, which is $181. Now, when we moved to talk about overpayments, one of the things that happened with this was that they were asking about your gross income when PUA is actually based on your net income. So that did provide some difficulty and is the basis for some overpayments at this point in time, but we'll deal with those when we discuss the overpayment issue. But that is basically why the documentation was required to support your weekly benefit amount, so that the amount could be correct and you could be getting more than the weekly minimum. In addition to that, you also need documentation to support the fact that you are actually self-employed from January through March of 2020. So that documentation is required to be provided when they ask for it, and you could receive a disqualification from PUA saying you were not self-employed and not eligible under the CARES Act. So keep in mind that those are the two main bases on which the PUA can request documentation. The one thing that is still self-certification is whether or not your lack of work was due to COVID. So just also, keep in mind that all of this documentation kind of plays together. Obviously, your tax return would support your weekly benefit amount. You would need to potentially supply your Schedule C for your tax return to support your self-employment. And then all of that, also potentially can be also used to support the COVID-related reason if you end up getting statements or affidavits from your employers about, that you were working, but that you stopped working because of COVID. So, just keep in mind that all of this does kind of play together, and, submitting more documentation than not is kind of a good idea at this point.
And right, just so we know what's going on here and we know how government fails us more often than not, these documentation requirements are to combat fraud, and they do nothing to combat fraud because most of the fraud was initiated and caused by the lack of protection of data by the Employment Security Division and the Employment Security Divisions among the 50 states. So putting the onus on the claimant and making them come up with these documentation requirements is wrong, and it just results in sort of a hypersensitivity on the part of the Employment Security Division to fault people when they don't exactly comply with what the Employment Security Division wants in terms of documentation.
That is.
I was going to be upbeat, but I can't be upbeat.
I know.
Because
It
this
is just, it is.
bonkers. It's just wrong. Anyway, okay.
That is true. But unfortunately, that was part of the Consolidated Appropriations Act and was enacted by Congress at the end of last year. So just keep in mind that if you cannot document your self-employment, you will not be eligible for PUA. Again, you could then potentially have an overpayment, which we'll talk about. One of the things that is true about overpayments, though, is because this requirement was only enacted at the end of 2020, if they determine, if DETR determines that you're not eligible, you cannot be, the money that you received in 2020 cannot be taken back from you. So this would only be prospective in terms of your overpayment. Anything you got in 2020, because this was a requirement from December of 2020, they can't go back and take your benefits from you. One thing to be aware of, though, is there are plenty of people who were not getting benefits because of the amount of time it took for PUA to make an eligibility determination. So keep in mind that this does apply to you for any weeks of benefits before December 2020. They just can't collect an overpayment. But it is something you might have to address in a hearing. So keep that in mind. We did kind of talk about this, so I'll leave this up here for a little bit, but just to say that get documentation, whatever documentation you can get. If you have a business license, supply it. If you don't, there's no harm in that. Supply your Schedule C showing that you had business related income for 2019 or 2020. Definitely be providing 2020 because one of the things you do need to show is the recent attachment to the labor market, which means you do have to have worked from January 2020 through March 2020. This also could be ledgers, invoices, any business accounts that you have, anything that you can use to substantiate that you actually were employed. And then finally, if all else fails, you can get signed statements from people verifying that you were self-employed and did work for them. It does say affidavits. Affidavits require a notary in Nevada. You can sign an affidavit under declaration by penalty of just saying, you sign declaring under penalty of perjury of what you say is true. So if you can get people to do that, please do so. But really just get documentation together showing that you had a legitimate business.
And yes, the rules say one thing, but what we often find is when you do have these letters from a prospective employer, I would have hired the claimant except for the pandemic. Oftentimes they're viewed with suspicion and determined not credible. So just if you have a tax form, if you have something that's from a third party that's not, from a friend or a prospective employer, that's going to carry more weight. It shouldn't be that way, but that's the way it is. They assume that anyone that they assume that you as the claimant are not telling the truth. And so you want to look for like a third party to verify that you had a job offer, you had a job, you had income. And that's why tax returns are so helpful, because you're sending that to the IRS and you're vouching for the authenticity and the truthfulness of it.
Yes, it's unfortunate, but true. So yeah, like the business license, the documents from any government agency indicating that you had an income or a job or whatever it is. I think marketing materials for business would be helpful too, but.
If you have a business, for instance, the state of Nevada, the Secretary of State will show, if it's a corporation, will show who the partners are or who the resident agent is or the people in the corporation. So that's a way to establish that this is a legitimate business. And if, Jane Doe issues the letter, I would have offered this job, and you show that Jane Doe is president of the ABC Corporation, then that's going to be very helpful.
That is true. You can do some investigation into the people, like if you were going to be doing work for a different business and you can say this is a legitimate business, then yeah, that would be helpful. But just, anything you can think of to support that you were employed at the beginning of 2020 is what you're looking for. All right, so that is just kind of going over the PUA documentation requirements. Before we move on to overpayments, any last thoughts about PUA or, sort of what's going on with PUA right now?
Well, we've seen here in Clark County that the county is encouraging people to find jobs because PUA does end the first week of September. So we're kind of closing in on that. We don't like to admit that, it's July of 2021, but it is, and these benefits will be ending. There's a possibility of an extension, but if they can't get an infrastructure bill passed, if they can't do anything in Washington, it's pretty much over in terms of PUA and qualifying as a gig worker or somebody who doesn't have an adequate wage history.
Right. And if you do go back to work, make sure you report it. As we're going to talk about in a second, if you don't report wages or income that you're making, it could be considered fraud. So you'll have a serious problem on your hands. So if you do go back to work, make sure you report it. David, did you have something?
No, if you go back to work and don't report it, it will be considered fraud. They always consider it fraud when you go back to work and don't report your wages.
Right. All right, so let's talk about overpayments. This happens to be a lot of the issues that we are currently dealing with. We're getting a lot of calls about overpayments. We're actually having an Ask a Lawyer on July 21st to try to help with getting people at least a conversation with someone to discuss their overpayment and what to do about it. So David, do you want to take us away with overpayments?
Sure. Well, it's always been the case with regular unemployment that you can waive the overpayment if you establish it's not fraud, it's not your fault, and collection of the overpayment would be against equity and good conscience. Now, the problem is that standard does carry forward with PUA and the federal benefits under the CARES Act and the American Rescue Plan, et cetera. But it changes a little bit, and we'll go through those changes. But basically, if you do get an overpayment notice, you need to contest it and file that appeal within 11 days after receiving the notice, and worry about the argument later. But the important thing is getting that appeal in, because if you don't do it within those 11 days, you may be waiving your ability to waive the overpayment.
And just, one of the things that we have also seen is that people are getting overpayment notices and their benefits are stopping. Now, as everything with DETR and ESD, this is unlawful. What to do about it is obviously a different question. Just know that should not be happening. You should, it's actually we're going to talk about a different UIPL, program letter 2021, that actually says they cannot start collecting the overpayment until you've had your hearing on your waiver request. But this is happening. Know that it is not correct. Obviously call us if you have an issue, but it should not be happening. But some of the reasons that we've seen for overpayments recently, the lack of identity verification still seems to be an issue. Not being eligible under the CARES Act because your lack of employment was not COVID related, not being eligible because you can't substantiate your employment. We just talked about that with the PUA substantiation requirements. But then also we're going one of the big things is if you, when the PUA system was rolled out, they asked for gross income when it should have been net income. And if you did not immediately supply your tax return, there could be a problem with calculating the weekly benefit amount. There's also problems calculating weekly benefit amounts when you're switching between programs, because the PUA and UI calculations are different. And so you could have been receiving UI, your UI ended, you were self-employed and had a W-2 job, so then you're eligible for PUA. That could have caused some problems because clearly they weren't making decisions timely, and you could have had payments that were over and above what you should have been receiving. And granted, all of these things, or a lot of these things, one, we are going to talk about fraud later, but these are not fraudulent issues. So, David mentioned the standard. We're going to talk about that next. Keep in mind that most of this is likely not your fault. That still doesn't mean that you shouldn't have to argue or you don't have to argue an overpayment waiver. So keep that in mind. It being not your fault is just the first step. So as David said, you can appeal, do so within 11 days. You can also file the waiver, do so within 11 days. But both are done through the online PUA portal or in writing, which you can fax, mail, or I don't know if you can hand deliver. I don't think you can hand deliver in Reno.
I don't think so.
Yeah, so just fax or mail in your UI overpayment. So just keep in mind, PUA is going to be online, UI is going to be in writing. And you can do both at the same time. So I would suggest don't, unless you know that there's no appeal right, that you definitely, there is an overpayment, but you shouldn't have to pay it back. You can file the waiver. I would file both an appeal and a waiver if you're appealing though, just to make sure that you have both on file. And as I said before, they should not be collecting the overpayment until the waiver determination has been made. Clearly, this is not happening for a lot of people. Still request the waiver, still file the appeal. If you win at your hearing, they would have to pay you back.
Well, and let's go back to that earlier point that you made, that they stop the benefits. And they shouldn't stop the benefits. They should give you a notice that you're not eligible, and you should have the ability to appeal that, but they don't. They just give you the overpayment notice. That's wrong. It's unconstitutional, probably, but they still continue to do it. And it's like, appeal it. You may be shocked. You may discover that you owe $14,000 or more or whatever. It's just, that's par for the course with this agency. They don't know what they're doing. They violate the Constitution, and they have you figure it out. And the one good thing is you do get the right to appeal, and you should appeal because it's wrong.
Right. And even if you don't know, I mean, let's say you don't know whether it's right or wrong, appeal it. I mean, at the very least, you'll get, a written decision saying this is why you have the overpayment. But also remember to file the waiver, because that is the request that even if you owe it, you shouldn't have to pay it back. And clearly, a lot of these are not your fault. This is not your fault. But whether you have to pay it back is a separate question.
And it goes back to, they're not available by phone. Sometimes that's a good thing, because sometimes they'll tell you, oh, you're not eligible for regular unemployment, so apply for PUA. And then 10 months later, oh, you're not eligible for PUA, you were eligible for regular unemployment the whole time. That happens a lot. And if you're given an overpayment notice, you just listen to what the worker at the Employment Security Division told you to do. So how is that your fault? It's not your fault, but good luck proving that. And that's the kind of incompetence that we see. They just don't know what they're doing, and they tell people to do the wrong thing. And it could be that they're doing the right thing, and then the overpayment notice is wrong. So it's just like, you don't know if you're coming or going. And that's really the problem. They have 10,000 appeals, maybe 5,000 are because of these erroneous determinations.
Right. There is no harm in appealing or filing a waiver. I'll just say that. And, not appealing, you give up valuable rights. So just keep that in mind. It's better to appeal and be incorrect than to not appeal at all. All right, so as David mentioned, the waiver standard, and we've talked about UIPL 2021. That's where this discusses the overpayments for the PUA, FPUC, MEUC, and PEUC, all these wonderful government acronyms. But David, the basis for a waiver.
All right, so the first factor, it's based on state law, is that you're without fault. And that's pretty easy. If somebody tells you to apply for regular unemployment or to apply for PUA and you're eligible for regular unemployment, you're without fault. If you apply thinking you're eligible because you're a casino worker and out of work as a result of the pandemic, when you do have a wage history and they give you a PUA, that's not your fault either. It's like, you're not required to know unemployment law and know the eligibility requirements. So 9 times out of 10, you're not going to have any fault because you just do what you need to do. Also, understand that PUA wasn't available until May 16th. So if you applied for regular unemployment when you were really eligible for PUA, I mean, that's not your fault. We're not talking about regular unemployment. I'm just saying these are examples of ways that you're without fault. You simply apply for the benefits thinking you're eligible, and it turns out you're not eligible.
Right. We will talk about fraud, but one thing is David mentioned, they might accuse you of fraud. This is not what we're talking. We're not talking about fraud. Like, just making mistakes is not fraud. Doing something that you think is correct is not fraud. Right, so just keep that in mind.
Sure, keep that in mind, but on their website, it says if you apply for PUA when you're eligible for regular unemployment, that may constitute fraud. So the fact that they have a jail cell and this kind of warning on their website shows the kind of mindset where they assume everyone's committing fraud until you can establish that it's not.
Right. So before we get into the against equity and good conscience, you can see the UI standard is similar: without fault, not the product of fraud, and against equity and good conscience. The one thing though about Nevada is equity and good conscience does not have an actual standard. There is no laid out standard of what constitutes equity and good conscience. And one of the things that the UIPL says is that if that's the case, you look at what the federal law says regarding the standard for against equity and good conscience, which is a 3 basic, point standard that says you can ask for a waiver if you can demonstrate financial hardship, or you have relinquished a valuable right or changed your position to the worse because of the benefits, or recovery would be unconscionable. So these are ors, and just keep in mind that, especially with number 2, that's true regardless of what your current financial circumstances are. So I know that in the hearing, if you're discussing an overpayment, the referee is going to ask you about your financial situation. Please be aware that there are 3 grounds on which you can ask for a waiver. Financial hardship is only the first one. So even if you are asked about your financial circumstances and you give information, please be aware that you can also argue that you change your position to the worst because of what you received from PUA, or recovery would be unconscionable. I don't know. Do you have any examples of what the second one would look like, David?
Oh, sure. Let's say, you get these PUA benefits and you buy a car and you have an expensive car payment. Even though you have income to pay off the overpayment, you changed your position for the worse. So in that situation, you detrimentally relied on the state indicating you were eligible for PUA. You incurred a debt, and now you have to pay that debt back, and it prevents you from paying the overpayment back, or not even prevents you, but it's more difficult. That would be detrimental reliance, and they should waive the overpayment. But these 2 other standards, detrimental reliance and unconscionability, the Employment Security Division isn't aware of that. The referees aren't aware of it. So they don't know the law, and therefore they're not going to go into these. They only go into whether you have a financial hardship.
Right. But, if you're in a hearing, it's your burden to request or show you should get the waiver. So you need to make sure you say these things at the hearing. Make sure you prepare written statements for yourself. Make sure you can even submit a written statement to the referee if you'd like to, but also you want to testify to what happened when you got the PUA benefits. I can even think of if you had taken out loans to pay for food and rent and utilities, and you had to pay those back when you got your PUA. So there are things that you can argue that meet these other 2 standards, but David's right. The burden is going to be on you to say this at your hearing.
Unconscionable, I mean, that's a tough standard, but let's say the PUA recipient dies and they want to collect it from the estate. That would be unconscionable. They're in a coma or something. That would be unconscionable. They're in the hospital. They may be able to pay it later, but it's unconscionable to try to collect it. Sorry. No,
we kind of skipped over unconscionable, probably because unconscionability is a somewhat common term in the law. But really it's, does it shock the conscience? Is there some reason why it would be seem really bad to try to take the money from somebody? All right. Now we've also talked about fraud. Please be aware that you might be accused of committing fraud. That doesn't mean you did. But unemployment insurance fraud is a thing and it is taken seriously. These are some reasons. I know we mentioned earlier, failing to report earnings. Failing to report earnings, if you work and you collect benefits and you don't report your earnings, this will be considered fraud. I mean, there's just really no way around it. And I mean, like, not even the excuse of, well, I didn't know how much I got paid until, later. I mean, no, if you are working and you are getting money, you need to report that to ESD. You do that through your weekly claim process. There is no real, difficulty in reporting your earnings. So you definitely need to do that. One of the other things is this big identity problems. People are getting accused of not being able to verify their identity and fraudulently applying for benefits. It is true if somebody uses the identity of another person, which was happening. I mean, somebody tried to use my identity to apply for unemployment benefits. So, keep in mind that this is happening, but you just need to verify your own identity and that you are the person you say you are, you have the eligibility in that. Showing up for the hearing should be enough. Although I have to say, David, I have heard that people have shown up for hearings on identity issues and lost. Not really sure what the basis is for that, but it is happening. So just make sure you're supplying your identity documentation.
I mean, the last PUA hearing I had, the referee said, "Are you the claimant? And you understand that you're under penalty of perjury, and if that's not true, you're committing fraud." So, yeah, I can see that happening, and it's absurd. That's the presumption that you're committing fraud and don't deserve the benefits. That's what the Employment Security Division always does.
And if you do commit fraud, you are not only liable for the overpayment and you cannot waive it, you are disqualified for 52 weeks. So you are disqualified for a year. And that's whichever is longer between when they found that you committed fraud versus when you paid the money. So it could be a very long disqualification from receiving benefits if you commit fraud. So don't commit fraud. All right. So as I mentioned, fraud is the one situation where you cannot ask to waive the overpayment. You have to repay it. So just keep that in mind as well. And there are penalties that come into that. 15% penalty is added, and it can be collected for 10 years. So keep that in mind. Again, though, this shouldn't apply to mistakes. This shouldn't apply to, I didn't know how to navigate the system. None of that is fraud.
No, I had a guy who did gross instead of net, and it's, you misrepresented your income. It's like, no, he didn't. He thought it was gross and not net. I mean, mistakes.
Right. And I mean, even the questions in the initial claims asked for gross income. So yeah, not fraud. But definitely, if you're receiving disability benefits, if you're receiving money from somewhere else while applying for benefits, that's definitely going to be considered fraud. And I'm not talking about Social Security disability, although that is a completely separate issue that we're not going to go into today. I'm talking about like if you are getting workers' comp or some sort of long-term disability benefit from your employer, you're not unemployed, you're not eligible for benefits.
And this is one of the problems, and it shows how the agency really doesn't care. When you get those overpayment notices, they ask you for the money. When are you going to set up payments? When you go to your portal, it's you have an overpayment. When are you going to start paying? And in the notice itself, it talks about fraud, even though it doesn't apply to you. It talks about fraud and how you can't get rid of this, and there's a penalty, and blah blah blah. It's like it's wrong to send somebody a notice that says please pay us when they have the ability to waive that, and the determination that they owe it is wrong. So it's like, if there's anyone committing fraud or misrepresentation, it may be the division that's doing that and not the claimant, but of course you can't collect them.
Right. And then finally, just a little bit about how overpayments are collected. They can set off future benefits. This is what happens with UI, almost 100% of the time, is they'll just offset future benefits. For PUA, they can also offset PUA, but they cannot take more than 50% of your PUA benefit. And, one of the things that, UIPL 2021 talks about our blanket waivers and other ways that ESD can waive overpayments. They can be waived if they're uncollectible or administratively impracticable, or if there were problems implementing the PUA system. I don't know that that's happening. It probably isn't, but you know, in a good world, that would be the case. In cases of fraud, this is where you see the benefit integrity payment program suing. They can do that. They can do administrative collection actions and sue to enforce the debt. You really only see this with fraudulent overpayments, but it does happen, and they can get a judgment against you. And then as far as costs and fees for regular UI, there is the ability to get fees. Normally what you see are interest and penalties. But again, that's, you know, just part of the overpayment process that they can collect. And then finally, you can discharge overpayments in bankruptcy.
Yes. And one of the joys I had was investigating this issue and figuring out that the bankruptcy court doesn't trust the Employment Security Division's definition of fraud. They will do their own independent investigation. And more often than not, it's not fraud. And you can discharge it. Even if the Employment Security Division finds fraud, the bankruptcy court will not find fraud and discharge the debt. And I should say, if it's a fraudulent debt, usually in bankruptcy, you can't discharge it. But the bankruptcy court does not have to rely on the state and their determination, because it's usually wrong.
But, you know, as I said, most of the time they're going to collect this from future benefits. And if it's normal overpayments, you know, that's basically where this is going to come out of. But if you're worried about it, again, bankruptcy is an option. You can definitely explore that. But that does it for our presentation today. As always, if any of you have any questions, you can pop that in the chat for the live stream and we'll answer them now if we can. Otherwise, if you have an overpayment question and you want to explore that in more detail with us, as I said, on July 21st, we are having an overpayment Ask a Lawyer. You can talk to a lawyer about your overpayment. So call us at any of these numbers to get signed up. You can also do an online intake and somebody will be getting back to you. But if you do call and want to you know, have an overpayment question that you want to talk about, please ask for the overpayment Ask a Lawyer. Otherwise, hopefully the person that you talk to will also get you signed up for that. But that is from 11:30 to 3:30 p.m. on July 21st. It will be telephonic. So just keep in mind, we're still practicing virtual social distancing due to the pandemic. So coming to the office on the 21st is not going to be helpful. It will be set up with an attorney by phone.
Yes, and you know, in the original CARES Act and all throughout these bills, the American Rescue Plan, the Consolidated Appropriations Act, this federal money, this PUA money, FPUC, MEUC, that doesn't have to be paid back to the government. So this is basically the state, the Employment Security Division, collecting these overpayments. The question is, when the program's over, what are they going to do with the money if there is money left over? And it kind of like begs the question, if they have 1 cent that's left over that didn't go to people who actually need the money and would help the economy here in Nevada and do what Congress intended it to do.
Right. It's just, you know, more evidence of problems with the system.
Yeah.
Well, I'm not seeing any questions right now. So thank you, David.
Thank you, Ray.
I think this will do it. Next week, I'm sorry, not next week, 2 weeks from today, we will be doing another live stream. So definitely check that out. I believe the topic right now will be habitability issues. With the global warming and increase in temperatures we're facing, habitability and lack of air conditioning is a hot topic for us right now. So I believe we'll be doing a habitability presentation in 2 weeks. That's July 22nd. But thank you all for watching. And David, yes?
Air conditioning in my office. Can I sue?
Well, actually, probably. I think maybe you should talk to your supervisor about that first. And I do enjoy David's background, the black hole, for a wonderful tribute, continuing tribute to Dieter and ESD. So thank you everyone for attending. Thank you, David, and we'll see you next time.